Well, Tyler Robinson is the alleged shooter in the Charlie Kirk assassination. This past week, we had the preliminary trial. We're going to talk about that preliminary trial and a whole lot more on this episode of Charlie Crimebuster, what some people are calling it the fastest minutes in podcasting.
The views and opinions expressed in this presentation are solely those of the individuals participating and do not represent those of city, county, state, or federal law enforcement agencies, nor sponsors and platforms of this presentation. The Charlie Crimebuster name and all forms and abbreviations are property of its owner, and its use does not imply endorsement of or opposition to any specific organization, product, or service. All individuals described or mentioned in the presentation should be considered innocent unless or until found guilty in a court of law. This presentation contains adult subject matter. Listener and viewer discretion is advised.
Well, hello and welcome to another episode of Charlie Crimebuster. I'm telling you folks, there's just so much material regarding the preliminary hearing of Tyler Robinson. In fact, I often take notes on legal pads, and my legal pad is full and running over. So there's no way we're going to be able to cover all of that in this one podcast. We could do this over several podcasts. However, if you're like me, a lot of us were really interested in seeing what would take place during these hearings. It took place over 5 days, and there's more to come. We'll tell you about that in a moment. So we're going to kind of summarize it for you today so you can get it all in one episode and kind of get up to date on what's happening with the preliminary hearing. Before we get to that, though, let me take a moment to welcome you to the Charlie Crimebuster Show. If you're a first-time listener, and it always amazes me that every day we have new people who click on a Charlie Crimebuster episode. We're now calling you an honored guest. And as an honored guest, we want to invite you to reach out with a shout-out. You can reach me, charliecrimebuster@gmail.com, charliecrimebuster@gmail.com. You can ask questions. You can make suggestions about other episodes you'd like to see us cover. You can ask questions about what we have covered. You can even lodge objections. That's right, something you don't disagree with, we'd love to hear from you, especially about this trial, because there's a whole lot going on out there on the super slab highway of the internet. So if you have some information you'd like to get to us, reach out with a shout out, charliecrimebuster@gmail.com. We will also invite you to check out our sponsor, peacemakernetwork.com. We're talking about those brave men and women who run toward danger instead of away from danger. Read all about it at peacemakernetwork.com. We are talking about law enforcement, first responders, and of course the military. Check it out, peacemakernetwork.com. Do me one other favor if you would, please. Please leave us a review. A 5-star review can help us get this episode out to more people. It can find its way getting before more people's feed, and in addition, more people can become a part of the family. So do me a favor, leave us a 5-star review. Don't forget to hit that subscribe button, because then you'll be notified every single time we drop an episode. Now, I do begin to know that what I first need to do in sharing this information with you is to share with you the difference between a preliminary hearing and a trial. Most people know that, but maybe you don't. A preliminary hearing is different than a trial. In a preliminary hearing, they decide whether there's probable cause to believe that the defendant committed the charged crimes. In other words, in this situation, will they be able to prove that Tyler Robinson probably did the deed? Now, it does not decide whether the defendant is guilty beyond a reasonable doubt. And another thing about this one, this is being heard by a judge only. There's no jury for the preliminary hearing. Now, in a trial, that's usually decided by a jury, but that is unless the defendant waives that right. I cannot see the defendant waiving the right in this particular trial, because on a jury, you have 11 people there. You have more people that you can turn to see if somebody will hold out and think that there was reasonable doubt in the case. With a judge, you only have one person, one go at it. Another thing about a pretrial hearing, or a preliminary hearing, I should say, the prosecution usually presents just enough evidence to justify it moving forward. Both sides in the trial, though, will present their full cases, including all admissible evidence. But the real important thing is this. In a preliminary hearing, the judge does not, let me say N-O-T, does not decide guilt or innocence. But in a real trial, or a trial, a full trial, not a real trial, but a full trial, opposite of what the preliminary trial does, the trial of a full trial, the jury or judge, which if it's a judge in a bench trial, will decide guilt or acquittal. So that's some of the difference. Now also, I should say that the evidence rules are much more relaxed in a trial that is a preliminary hearing. For instance, in the state of Utah, they will allow in a preliminary hearing hearsay. But in a full trial for guilt or innocence, well, the normal rules of evidence is actually followed. Now, in Tyler Robinson's case, it was a week-long hearing, and it was held to determine whether prosecutors had shown enough evidence for the case to proceed to trial. They did present surveillance video, DNA evidence, witness testimonies, and digital evidence. And the defense came back and challenged the strength and reliability of that evidence. In other words, they were able to cross-examine. But please remember, the bar is very, very low in a preliminary hearing. You do not have to prove it beyond a shadow of doubt, or beyond a reasonable doubt, I should say. You do have to show that it's probable. In other words, he probably did this. Can't say for sure that he did it, but based on what we're seeing, he probably, more than likely, probably did this deed. And Judge Tony Graff is not deciding whether Robinson is guilty, but he's deciding whether there's enough evidence that a reasonable person could believe, probably believe that these offenses are as charged. If so, he will then bind that case over for trial. So if he does find probable cause, then it's going to be bound over for trial. Now, this preliminary hearing, though, was a little different than most that you and I know about. It was much longer. There was a lot more evidence that was actually presented. Usually the prosecution will only show just a little of the evidence. This time, the prosecution seemed to be intent on showing more than enough evidence, in my opinion, to say that Tyler Robinson probably did this. But Utah is different. Preliminary hearings there are often more extensive than those in many other states. Prosecutors sometimes present significant portions of their evidence, and witnesses can be cross-examined. But keep in mind that legal standard remains just the same. It's much, much lower than at a trial. Probable cause instead of proof beyond a reasonable doubt. So if you have been following this trial, I'd love to hear from you. Do you think that they were actually able to put on enough evidence to show that he probably did it? Do you think that this will be bound over to trial or not? I'd love to hear from you. Reach out with a shout out, charliecrimebuster@gmail.com. Now, in just a moment, we're going to talk about some of the rulings that the judge actually brought to the court on the evidence that was submitted. There were three things they were looking for. Number one, are we going to submit this evidence? Will it be submitted? Will the judge allow this evidence to be submitted? Number two, if he allows it to be submitted, will he allow it to be published inside the courtroom? And number three, will he then allow for it to be published not only inside the courtroom, but out in the public as well? They did a whole lot of talking about that this week in this trial. Now, while this is a probable cause hearing, there were several decisions that were made about evidence. We do find that Judge Kraft did make several important rulings. Number one, he allowed prosecutors to present surveillance videos. These videos, they say, show that Robinson's movement before and after the shooting. Now, the defense argued that these videos could unfairly prejudice future jurors, but the judge permitted them to be shown for the purposes of a preliminary hearing. Number 2, he did restrict some highly sensitive video evidence. For the actual shooting footage, the judge did view portions on his own monitor, but he did not project them publicly, while the courtroom did hear some sort of audio. This was done, of course, to limit unnecessary public dissemination of graphic materials. He also excluded parts of the roommate's recorded interview. Prosecutors wanted to play parts of Lance Twiggs' interview. The defense argued that would amount to presenting alleged confessions out of context. Judge Kraft did bar some portions of that while he allowed certain other portions to be presented. He also put restrictions on newly admitted exhibits after a court era. One document, unfortunately, was accidentally displayed publicly, and then that was a mistake. The defense sought then to say, hey, let's just bar cameras, period. Well, Judge Kraft declined to close the hearing, but he did order tighter controls on displaying some of these new omitted exhibits to protect the defendant's fair trial rights. The key question, though, keep in mind, before the judge is always going to be whether the prosecution presented enough evidence to establish probable cause that Robinson committed the charged offenses. That's a much lower standard than proving guilt beyond a reasonable doubt. Now, in finding that question to be answered, the judge will then consider evidence, including DNA evidence that link Robinson to the rifle and related items. He'll consider ballistic testimonies coming from the weapon that fired the fatal shot, and the surveillance videos that placed, allegedly, Robinson near or on the rooftop that they identified as a shooting location, and also testimony from Robinson's former roommate about statements that Robinson made after the shooting. Now, the defense, of course, will challenge the reliability of DNA, the ballistics, and, of course, video evidence. Again, if the judge finds probable cause, this case will proceed to trial. Now, in just a moment, I'm going to share with you some of the most exploding parts of evidence that came out this week. Some things that I found out that I did not know before, and no doubt some things that you will find out that you did not know before. We're going to get to that in just a minute, but right now it's time to pause, take a deep breath, and share with you what we call Charlie Crimebuster's Crazy Crook of the Week. Well, our Crazy Crook story today, unfortunately, no, again, it's another Florida man. Yep, Florida man. The headlines goes like this. Florida man crashes his pickup, then drives a tractor back to the scene to rescue it. Now, that doesn't sound very crazy, does it? You wreck your pickup, you get it on your tractor, you go back, pull it out of the ditch. Happens a lot on farmlands. I was raised on a tractor in a farm, and I know all about using a tractor to pull things out of the ditch. There are many ways, though, to handle such a vehicle accident. You can call a tow truck. You can call a friend. You can call your insurance company. And you can wait patiently on hold for 45 minutes while listening to some music. But what you probably should not do, my friend, what you probably should not do, unless you're a crazy crook, is leave the scene, grab a beer, grab another beer, and then grab a tractor and drive it back to the crash. And yet, here's where we are. On June the 24th this year, deputies from the Nassau County Sheriff's Office, that's up there it's up near Callahan, Florida, actually. I was going to say Amelia Island, but it's Callahan, which is near there. Well, they responded to a single vehicle crash involving a white pickup truck. It had ended up at an angle in the grass on the side of the road. By the time they arrived, guess what? The driver was gone. But a witness on the scene told deputies that he saw a man walk off to a nearby residence. Well, that's fair enough. Seems like a solid plan at the time. But then, plan kind of went sideways. That's when the driver returned. Not on foot, not in a ride share like an Uber, but on a tractor. And body cam footage captures the moment that he pulled up to his own crash scene on the farm tractor, ready to hook up the pickup to the tractor and tow it home like we do back in farm days. It's really not the worst idea. Tractors have serious pulling power. But there was a problem. You see, the deputies noticed that when the driver stepped off the tractor, he stumbled, fell over it. That's generally not a great sign, is it? And then a field sobriety test followed, and the man was arrested for DUI. And surprise, 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 inside that crashed pickup, investigators found a 15-pack of cold beer. Multiple open containers sitting on the floorboard, and the truck's front end also appeared to be torn up, which the driver said he could not explain since he had not been paying attention while he was talking on the phone. Did you get that? Now he's telling them he was using his cell phone while he was talking. Well, the deputies had to explain to this crazy crook that DUI laws in Florida, well, they apply to any motor vehicle being operated on public roads. Driver said, boy, I didn't know that. Well, Florida Statute 316.193, yes, that does define DUI as operating a vehicle while impaired. And that term vehicle, well, it covers a lot of ground, tractors included. No exception for farm equipment, golf carts, or anything else with wheels and an engine that you might use to move yourself from one place to another. If you can recall some of our crazy crook stories, we've even arrested here in Florida people driving lawnmowers. Yep, driving lawnmowers. So this crazy crook who thought it would be a good idea to go home, have a couple more beers, and get on his tractor and go back to the scene of the accident when the cops were waiting, well, he is indeed Charlie Crimebuster's Crazy Crook of the Week.
Florida has warm weather throughout the year, and having an air conditioning system is important. Whether it's summer or winter, you'll always need your air handling system. Breezy Air Incorporated provides both commercial and residential air conditioning solutions. Solutions that are built for your comfort needs. Call Jack at 407-283-2327. You see, Breezy Air provides solutions that bring cool comfort and reliable service to their customers. Preventive care can also lengthen the life of your AC unit, and believe it or not, Breezy Air provides annual service packages. So call them today, 407-283-2327. That's 407-283-2327.
Now, friend, I got to tell you, it's a whole lot tougher for me to bring these things to you when there's just so much information. I want to try to share with you some of the things that you really need to know about during these 5 days, but there's no way we can cover 5 days in the short time that we have together here on the Charlie Crime Train. But I'm going to share with you some things that really stand out. Number one, the video surveillance that we saw during the trial. Here you could see the alleged shooter as he arrives at the campus early that morning around 8:30. You could see him get out of his car, walk across campus, walk up to the Turning Point USA people that were there getting ready for the event that day with Charlie Kirk coming to debate people on the college campus. No doubt talk to them about when Charlie might arrive, where Charlie would be set up at, something that you would ask if you wanted to find a good place to sit to watch the event. No doubt, Turning Point USA representative, whether it was a college student or whoever it was, did not know that he was really casing the place out, did not know that he was really looking at the best place to take a shot at Charlie Kirk. Then he leaves, gets in his car, drives away, comes back again, gets out of his car again, this time with a backpack. He walks over to some woods. Then he comes back, he leaves again, goes to Chick-fil-A, gets something to eat. That really blew my mind. I mean, you're getting ready to do something incredible. You're going to take a shot. You're going to try to kill someone. And you are cool enough that you go to the Chick-fil-A and you sit down and you eat. And yet that's exactly what happened. Comes back. This time he is in different clothes, dressed in black. And there's something else very different. I often ask myself, how in the world did he get a rifle up on top of that roof without somebody seeing him? Whoever the alleged shooter is, whoever you believe the alleged shooter is, how did he do that? Well, the surveillance video gave us a really good look at it. as he was walking with a limp. And you could see it looked like there was something down his pant leg causing him to limp. He could barely get up the stairs because there was something in his pants that was prohibiting his walking gait. Now keep in mind, before then, he had no problem going up and down the stairs. He had no problem walking around. But now, with long pants on, hiding what he has down in his pants, which I believe, and most anybody reasonably would believe, that was that rifle. That was that long gun that he took up there on the roof. And then in the surveillance video, you can see the subject getting on top of the roof there at the Lewis building, going to the corner, lying down, and we know the shot took place about that time. You can see him get up, running to the other side of the building, jumping off the building, and then walking across the grass. You can see all that happening on the surveillance video. When the investigator was asked, how do you know that that's him? He could say, well, because of the way that he looks, because of the shirt that he had, because of the sunglasses, because of the shoes that he had. There was distinctive ways of pointing that out. How did you know it was his automobile? Because of the shape of the automobile, because the wheels were distinctive and stood out, and also because they had a tag number that came back to the subject, Tyler Robinson, the alleged shooter. So this surveillance video, I believe, is huge, particularly in the fact that it brings about how he could have gotten that long gun to the roof to make the shot. Now, it is true that usually when you look at this thing, in 7 seconds, he got on the roof, crawled over, took the shot, and then left. 7 seconds is not a lot of time, but it's plenty of time to take that shot. And remember, he only made one shot. In the Butler assassination attempt of President Trump, there were several shots. People were able then to look and to see where it came from. He made that shot so quick and moved so quick that a lot of the people in the crowd did not catch that there was somebody on the rooftop taking that shot. Because we have the video now, though, we can go back and look and we can see it. And we can see the chaos that came, and we can see how he could leave there and get away with this at this point because of the chaotic scene that was there. So I think one of the number one things that stands out to me is how he got the gun to the top of the roof. There was a second thing that happened, though, that was pretty incredible as well, that also told us some stuff that's really incriminating, in my opinion, about the alleged shooter. They actually had an interview with his roommate, and there was some really damaging things that came out of that. There was no doubt a confession that was made to the roommate. There was a note, according to text that was read at the trial, that was placed under the keyboard, according to the testimony of his roommate. He got the text, told to look at the note. He looked at the note, and the note basically told him that he had shot Charlie Kirk. And in the text messages, now we weren't able to see all the text messages in the hearing. We were not able to see some of the other text messages to other people. Those were actually prohibited to be presented at this time because of maybe it would prejudice the jury pool. But what we did see was plenty incriminating. We saw where he said, "Did you do it?" And he said, "I did it." We hear from his roommate as he's testifying in his interview that he said, "Were you the person that did it?" He said, "Yes, I am." We hear about how he said when he got home, "Did you do this?" "Yes, I did this." And he said, "I'm sorry I did this," as he was crying. There was no doubt in anybody's mind who could look at this reasonably that this was a bona fide confession to his roommate. And as young people do today, they just cannot keep from texting. They would rather text than they would talk on the phone. And when you text, it's just about, well, let's put it this way. Several years ago, I had a friend, a good friend, and his parents was an attorney. And he said, "My mom and dad always told me that if I did something wrong, do not put it in writing." You know, you can say he said, she said, but when you put it in writing, you're done for. Well, when he puts it in text, and that text can be contributed coming from Tyler Robinson to Twiggs, his roommate, that is pretty incriminating. He did confess that he did it. He even talked about where he put the rifle. He even talked about he was trying to get the rifle back when there were people around it, and how he needed to get that rifle back. How he said, that's the only thing that can tie me to this case, my fingerprints on the gun. Why did he say that if he didn't do that? I'm telling you, friend, this in itself is enough probable cause, I believe, to hold this trial over. But it wasn't only the testimony from the roommate. It wasn't only the damaging texts for the defense that was released during this preliminary trial. There was also DNA evidence. DNA evidence that was found on the screwdriver that was left up there in what one of the investigators termed as a sniper's nest. That screwdriver was left there. When he was talking to the roommate, he also talked about this instrument that was used to etch certain words on the bullet. No doubt in the coming trial, and I believe there will be a coming trial unless he pleads it out, we're going to hear about what was etched on these bullets that were there, tied back to the roommate, identifying the fact that his roommate, Tyler, asked him, where is this instrument that we can use to etch these bullets? He told his roommate he was going hunting, but then he took that back and said he was using it. All of this was a ruse to get him to this campus to where he allegedly shot Charlie Kirk. And then there was the motive. Why did you do it? And it came out in the preliminary trial. He said because Charlie Kirk was spreading hate, and some hate cannot be negotiated. So there you not only have the confession that he did the deed, but on top of that, you have in this preliminary trial a motive for taking Charlie's life. And then he told his roommate that he was going to turn himself in, that his father and his mother and a friend who was a deputy sheriff was going to go with him to turn himself in. And then we have the video of the father and the mom and the friend coming with Tyler Robinson to the sheriff's office to turn himself in. And no doubt they're going to point out the similarities to the video that shows him walking into the sheriff's office to the video that they showed with him on campus. No doubt in my mind, folks, there is plenty enough stuff that was left during this preliminary hearing to give more than probable cause to bind this over to trial. Now again, that doesn't prove without a reasonable shadow of doubt, because we haven't gotten there yet. There's going to be a lot more evidence that I believe that's going to come into this trial, this coming trial, should the judge rule that there was probable cause. I believe he will. Most anybody I've talked to believes that the judge will do it. But after he does that, there's going to come a trial, and I will guarantee you there's a lot more evidence other than this. Well, what is the defense doing? We can also see what the defense will be doing in the trial. They're attacking the DNA. They're saying that DNA isn't a 100% accuracy science. And that's true. That's true in all DNA. I mean, you can say there's 1 in 1 million chance that this was not Tyler Robinson. That's a pretty big chance, I mean, that to me shows beyond a reasonable doubt. But you know that they're going to attack the DNA. They set this up in their cross-examination, showing that there's certain things that people can't say. And you'll see this in every trial. They can't say without an absolute certainty that it was that person. They can't say that it's 100% accurate. But, my friend, DNA has been accepted because of all the crime dramas on TV today, because of the past trials. DNA has been a very strong component to guilty verdicts from juries. And DNA will be a big, large part of this. It will be attacked by the defense. There will be several other ways. And we can see from watching this defense work in this preliminary trial that now they've been trying to think of several ways to defend Tyler Robinson, and he deserves defense. He is not guilty until proven guilty. And that's true of anybody of any crime. And he deserves that. And we're going to give him that opportunity if there is a trial. But, my friend, I've got to tell you that the defense showed its way here. Now, at one time they were talking about maybe considering an insanity plea, but then they got off that real quick, because if they do that, they got to admit that he did it. So now they're coming back, and it seems to me that their plan of attack is going to be to attack the evidence, to attack the people that are doing the investigation. That's what we're going to see if there is a coming trial. Now, I say if there's a coming trial because, get this, the judge hasn't ruled yet. They're going to come back. They're going to each show some briefs, both the prosecution and the defense, to the judge. He's going to look at that, and then on September the 1st, they're going to be able to argue orally why, number one, he should be held over for trial, and number two, why he should not be held over by trial. My belief is, as many experts will tell you, there is more than probable cause to bind him over. But I'm not the judge. What do you think, based on what you've heard today, based on what you followed in the trial, if you have the preliminary hearing? Do you think there's enough probable cause to hold him over? I believe he does. You say, well, you're just biased. You're a former law enforcement. You're retired law enforcement. That's the way you're going to go. Well, I tried not to be biased in this. I tried to look at the evidence, and I believe the evidence overwhelmingly says there's probable cause to hold him over for trial. But I'm not the judge. Maybe you see other things. Maybe you've listened to other podcasters. And by the way, my friend, this is why we at Charlie Crimebuster, we follow the evidence. We're not going to get on here and just speculate. We're going to follow the evidence. What I've shared with you today is the evidence that's been presented at the preliminary hearing. Evidence that I believe establishes probable cause to bind this over for trial. So here's the question. Number one, do you think, based on what you've heard, there's enough probable cause to bind him over for trial? Tyler Robinson. Number two, do you believe that the judge will rule that there is probable cause or not? And number three, if he does bind it over, do you think there'll be a trial, or do you think there'll be some sort of plea? Some sort of plea, maybe to get the death penalty off the table. And if they do that plea, will the prosecution agree to it? Will they agree to take the death penalty off the table? So lots of questions. I'd love to hear from you. Reach out with that shout out. charliecrimebuster@gmail.com. charliecrimebuster@gmail.com. Boy, I'm telling you folks, there's just so much stuff here. I hope I've gotten the part over to you that I think is really, really more central in this investigation. And I am asking you to comment. We'd love to hear from you on this. If this is a trial that's going to be coming up, sadly to say, I think it's going to be some time. We're already almost a year in September the 1st when he's going to let them present oral arguments. That's almost a year from the time this took place. And I'm sorry to tell you, it may be a whole nother year before this goes to trial, if it goes to trial. Why? Because the death penalty is involved. They're always going to give more time for preparation when the death penalty is involved. Who knows? We'll see. Well, folks, thank you for joining us on this episode of Charlie Crimebuster. We look forward to next week when, again, we'll share with you a Charlie Crimebuster crime story. So until this time, next time, this is Charlie Crimebuster reminding you, be safe, be alert. Yep, for the life you save may be your very own.
You have been listening to Charlie Crimebuster. We would like to thank our sponsor, the Peacemaker Network, and also encourage you to support the first responders, military, and law enforcement personnel by contributing to the Peacemaker Network. That's peacemakernetwork.com. All music and sound effects are courtesy of Pixabay.com. That's Pixabay.com. You can also support us by subscribing to our YouTube channel, tag @CharlieCrimebuster, and then click the subscribe button. By doing so, you'll be notified each time we drop one of our shows. Another more convenient way for you to listen to our podcasts, or for you to say to your smart speaker, play Charlie Crimebuster. If you have comments or suggestions, we would love to hear from you, so please send them to charliecrimebuster@gmail.com. That's charliecrimebuster@gmail.com, or you can call or text us at 407-917-2211. That's 407-917-2211. Thank you for listening, and we hope that you will join us again for another exciting crime episode with Charlie Crimebuster.